All rise. The Court of Appeals Division 1 is now in session.
Good morning. You may be seated. We are, to give these to you.
Thank you.
We are here today in our case number 1CACV 140689, State of Arizona versus Yee, I think. Counsel, as you know, both of you know, we record these proceedings. So when you approach the podium, please recite your name and the name of your client, so we'll know when we look back on it who you represent. And for the appellant, each time you approach, please do that. As you know, both sides are allowed 20 minutes. The appellant may reserve any amount of time that you'd like to use in rebuttal, but you must keep track of your own time. With that, you may proceed, Mr. Abney.
Thank you, Your Honor. May it please the Court. My name is David Abney, and I'm representing the appellant, Mr. Ayiyi. I can't even pronounce his first name. It does not pronounce the way it looks. Mr. Ayiyi wants to obtain a court-ordered paternity testing. We submit that there's two paths to get there. One would be ARS Section 25812, Subpart E, and the other would be ARS Section 25503. And I know that the Andrew R. case is a severe impediment to this.
It's a what impediment? I'm sorry, Counsel.
It's a severe impediment to what we want to do. The difficulty is that case said that essentially you're incorporating Rule 60 into the statute 25812, and because of that, you have a 6-month time limit in order to get relief. In Andrew R., it was somewhat unusual. I guess maybe all these cases are unusual. I don't know if there's a pattern. It was the mother trying to say that the person who had signed the acknowledgement of paternity was not really the father,
Trying
the
to
biological
exclude
father.
someone from the
Right.
party, yeah.
And she brought a motion under Rule 60C at the time. It's been changed to 85C, and the motion said fraud and duress. The duress comes out of the statute. I think there's a distinction here because when the statute itself talks about you can do this on the basis of fraud, duress, or material mistake of fact. That only partially matches up with what's in Rule 85C or 60C for that matter. 85C1A talks about mistake as being a basis. 85C1C talks about fraud, misrepresentation, or other misconduct of an adverse party. But the duress in this case is not the misconduct of an adverse party. The duress that was imposed upon Mr. Ayiyi came from his mother and father and the cultural values of the Nigerian culture, where a grandson and son are so highly prized that the parents insisted that their son sign the acknowledgement of paternity and accept the child as his own, even though he had doubts about it.
Counsel, can we talk about that for just a second? If you can go back to the beginning, I think it would be helpful to me in understanding a couple of things. The child is born, and we know that, about 7 weeks later, they sign off on the statement, the
Acknowledgement of paternity.
Acknowledgement of the paternity.
Yes, Your Honor.
So it's about 7 weeks. Later, when the issue comes up of the child support, he says, well, wait a minute, within 2 months of the child being born, I got genetic testing, correct?
No, it was a little bit longer than that. It was about the 8-month mark.
Okay, so you're saying that at 7 weeks, they do the acknowledgement. About 6 months after that, a little over 6 months after that, then he gets the test results.
Right.
So then, for all intents and purposes, then nothing happens of chronological significance until about what, 7.5 years after that.
It's at about the 6-year mark, she comes to him and says, I think the mom comes to him and says, I want the test results. And he's going to produce the test results for her, and then we get one of these strange dog ate the homework sort of situations where he says he put it in his car and then his car gets stolen, and the company's out of business, and he says he can't get another copy. You know, I think it'd be up for the trier of fact to go through that scenario. But he doesn't have anything to give to her, and she doesn't do anything then. The next thing he gets is at about the 9-year mark when ADES sues him and wants child support, just going forward, doesn't want back child support. They sue him for forward child support. The story actually started a little bit earlier than you suggested. While the child was still in utero, she presents him with she goes to his parents with an ultrasound and says, you have a male child. This is almost biblical. I mean, you have a male child and the trumpet sound, and then the parents gear up the pressure on their son. Now, in some cultures, in American culture, many sons would say, that's nice that you think that way, Mom and Dad. I'm going to do what I want to do. And you're not going to force me to sign anything, but duress comes in many forms, and the way you're raised affects how you react to your parents. I mean, if you actually went back to the Bible when it says, honor thy father and mother, that had a lot of teeth. You could be put to death if you didn't honor your father and mother. And Nigerian culture is a very strong culture, apparently, at least that's what's been presented to the court, and that they pushed him hard to sign the acknowledgement of paternity, and he gave in.
But for 8.5 years, he knew this wasn't his child to a 95% likelihood of 95%, as I understand
Correct.
it, but did nothing to address the Nigerian culture issues as to who his real son was.
Well, he didn't do anything, but then again, there was really nothing for him to do. When he presented the paternity test to her, she stopped bringing the child over, and all contact was cut off. Nothing happened year after year until about the 6-year mark. She asked for the test results, and then when they weren't forthcoming, when he didn't produce those, nothing happened year after year until you get ADS coming into the picture at the 9-year mark.
Can we go backwards? I understand you to be drawing a distinction in terms of the type of duress at issue here versus Andrew R., but I'm not understanding what difference that makes under 25812E and Rule 85C.
Well, 25812, I'm not sure how. Well, Andrew R. seems to incorporate Rule 60C, 85C into the statute. And that's, that's precedent. But exactly, if that's going to be how it's done, then you would really have to parse exactly what has been incorporated. And 85C and 60C don't say anything about duress or misconduct by somebody other than, they don't say anything about duress.
Well, but I think if you read 25812E, which says that after the 60-day period, you can challenge only on the basis of fraud, duress, or material mistake of fact.
Correct.
So let's say it's any kind of duress, and the kind of duress you're talking about is recognized. It still brings it within the time limitation of Rule 85C, doesn't it?
No. If you want to parse these very closely, it doesn't, because
I'm following that part.
85C talks about mistake, and it talks about fraud. It doesn't talk about duress anywhere. And you could shoehorn that in under subpart C1C, where it talks about fraud, misrepresentation, or other misconduct of an adverse party. You could shoehorn duress into there. But this is not duress by an adverse party. This is duress by his own family, and that's not an adverse party to this proceeding or any others. It is duress, so it's outside. If we want to be technical about it, it's outside of the scope of Rule 85C1C, and it's not anywhere else in 81C, so you would drop down then. This would be some other reason to provide relief, which would be Rule 85C1F. And that would be an avenue where you could actually have 25812E apply. Plus you have that odd at any time, and I know Andrew R. sort of read that out, but maybe if you don't have something that really fits 85C, you should read it back in. That at any time means at any time. If you can show duress at any time, then you would be able to go forward. And of course, then the other statute where you do get testing would be 25503F, which has no reference to 85C. And while it doesn't say at any time, it does say the court shall order. And-
But that's if there's the presumption established under 814, which we're not dealing with.
Well, and I say, why not?
Well, because there are the two pathways, and this one took the 812 pathway.
Yes, but if you take a look at 25814A subpart 4, it talks about a notarized or witness statement signed by both parties acknowledging paternity. Isn't that an acknowledgement of paternity, which is what he signed?
Like a lesser included of an 812.
Yeah, like a less,
But the 812, the filing gives it magical qualities of a judgment, and
Well,
so I think that
it-
makes the distinction.
If I can bring the two statutes together, all right. 25503F talks about someone who's been ordered to pay child support under a presumption of attorney that's established under 25814. Then you go to 25814A4, and we're right back at the acknowledgement of paternity. So this 25503 subpart F is talking about Mr. Ayiyi. He is someone who's been ordered to pay child support under this presumption of paternity.
But he's really not. It's not a presumption, it's a judgment of paternity.
Well, I know, in normal speak, we would do that, but presumption of paternity here refers us back to 814, where it says a man is presumed to be the father, and then you go to 4, which is the acknowledgement of paternity. So, I mean, it's referring you right back to where you start, where he was a few months after the birth. He signs the acknowledgement of paternity. So if you read 25503F in conjunction with 25814A4, that makes 25503F apply. And then you're back to one of the real roadblocks in all of this mess is the way the statutes are written. You start out, everything looks fine, and you talk about, the court may order this and may order the testing. And then you get down to the sentence that says, in both statutes, the court shall order. And there's a disconnect. It's like somebody left out a sentence in between these two concepts. The court, the court may order and then the court shall order. What triggers the shall order? And if you say, okay, you shall order when paternity is established by fraud, duress, or material mistake of fact. But why would you need any testing if you've already established that paternity was established by fraud, duress, or material mistake of fact? There really needs to be a trigger here for the shall ordering, and I suggested to the court, sort of legislating myself, and maybe it's a little dumb, but I suggest maybe a plausible showing that there has been fraud, duress, or material mistake. Maybe that's what the trigger is supposed to be for shall ordering, that you've come into court and you've said, look, there's an indicia here of fraud, duress, or mistake. Duress is very strong. You've got proof of it. Maybe you and I would not give into that kind of duress, but he did, and it was there. Or maybe the trigger is fraud. The odd behavior of the mother. Maybe she's embarrassed to ask for child support. Maybe she has plenty of money, doesn't want to bother him about child support, but to stay back for so long and not even ask for it is a little strange. It makes you wonder, well, maybe she thought this wasn't his child.
Is there anything in the record that tells us when the acknowledgement of paternity form was filed with DES?
I am sure it is. I know it was shortly after the birth. It was
There-
within. I can't
I
put my fingers on
I
it.
see it was signed about 8 weeks later.
Yes.
There's a date stamp in the
N-
lower
yeah, there's a
right-hand
date
corner.
stamp.
Yeah.
Maybe that's the
2
filing.
weeks later,
Yeah.
arguably
That's,
2 weeks later.
he definitely signed it. No
Well,
question.
but-
And he
but-
signed it quickly, too.
But it may, depending on how you read the statute, it may achieve the magical power of a judgment only upon filing. So perhaps to ascertain that it was filed and when might be of significance.
I will
But that-
investigate and see and I will
Uh,
provide a supplement if I find the answer to that question. But for purposes of this, we believe that the judgment was,
That it was filed a long time ago.
well, the equivalent. I believe that we have to address this acknowledgement of paternity and treat it as if it were a judgment.
Okay. And your argument is,
Because I think that's the legal effect of the acknowledgement, is that you treat it like a judgment.
yeah, I think the statute may be a little bit unclear about whether it achieves that status upon execution or only upon filing, but in any event. Your argument is this is duress of a sort that's not addressed in 85C.
Yes, Your Honor.
It's addressed in, it's some other reason which opens up the time frame.
Yes, Your Honor, that's one of the arguments. And then the other argument is that 25503 subpart F would apply also. So there's two paths to get the testing. And if the testing comes back, it may say, congratulations, Mr. Ayiyi, you're a father. Or it may say you're definitely not. And in either event, then we will have some sort of progress, either finality or further support for the notion that there's a problem that needs to be corrected and should be corrected. But as things stand now, we don't have that knowledge. The Andrew R. opinion is a very interesting opinion. I like the dissent quite well. I think Judge Weinstein hit the nail on the head. He starts out by saying something to the effect of, if we live in an era where we can have scientific certainty, why not make use of that? So many of these presumptions came about for centuries of the common law trying to deal with the unfortunate biological fact that there's one mom, but there could be any one of a number of fathers. That's just the way biology has set things up. And the common law tried to deal with that with helpful presumptions. But maybe we should rely a little bit more on science.
Okay.
Thank you.
Thank you.
May it please the court, my name is Carol Salvati. I'm the Assistant Attorney General representing the state of Arizona, XREL Department of Economic Security. As the state did in its answering brief, it will be referring to the appellant as father. I would like first to respond to the court's question about the filing date of the acknowledgement of paternity. It is the September 13th, 2005 date stamp that shows when it was filed with the Department of Economic Security, and that's Index of Record on Appeal number 29, attachment A.
Counsel, when that is filed, is there anything sent out to the parties or the persons that are signing the document?
I don't know. And the other thing that I wanted to point out to the court is that during the hearing in the 4D court, father did state that he believed it was about 2 or 3 months at the time when he allegedly had the child genetically tested. So that's when, and so the child could have been as early as 2 months old when the father allegedly had the child paternity tested.
Which would have been within a week or two of the signing of this presumption, correct?
The child was about, the child turned 2 months old just 5 days after father executed the acknowledgement of paternity.
And then he would have gotten the DNA tests almost immediately.
Yes. By his own testimony.
You said between 2 and
3 months.
3 months,
It's,
okay.
yeah, page 12 of the hearing transcript. He said, I believe it was about 2 or 3 months.
So within 2 or 3 months, he's in possession of his answer?
If he did obtain the genetic testing, then it would have been at that time.
Well, if we hold him to his testimony, then he knows within, maybe a little more than 2, but somewhere less than 3 months after the birth of the child, that he's not the father.
Yes, Your Honor. But he has alleged all along that he knew he wasn't the father because he alleged in his Rule 85C motion that he had terminated his sexual relationship with the mother a full year before the child was born.
Well, it seems, setting aside the argument that Mr. Abney raises this morning about the particular form of duress, it seems, if you turn the issue just a little bit, that the case may turn on the distinction between and an acknowledgement that is executed and witnessed under 814, and an acknowledgement that is executed, witnessed, and filed under 812. The latter has the significance, or the latter is treated as a judgment, the former is not. What's the rationale for the distinction? Is there any rationale?
Yes, that the 25812D for the determination of paternity that has the full force and effect of it as a judgment, it has a couple additional requirements. And if those two requirements are met, then it becomes the determination having the force and effect of a judgment. So the two extra requirements are it must contain the parent's Social Security numbers and then the filing with the Department of Economic Security.
So the Social Security number also distinguishes it from the 814.
Yes, Your Honor.
Why do those two elements make a difference?
It's just a more formal and more specific process. So if you look at the two statutes, the presumption, which is the mere presumption under Section 25814A4, that requires nothing more than a notarized or witness statement signed by both parents acknowledging paternity. Under 25812D, we need that acknowledgement, plus those other two requirements. And in terms of statutory interpretation, this more specific statute always controls. So in distinguishing between the presumption and the determination with the force and effect of a judgment, it is the more specific statute that controls.
So was I'm sorry.
I was just going to follow up on Judge Johnson's question. Wouldn't it also be true that an acknowledgement under 812 carries far more official legal significance, such as it amends the birth certificate? It possibly, probably triggers Social Security benefits or death benefits. It is a legal judgment in every sense of the word, whereas an 814 acknowledgement is of far lesser stature, which would make sense that it's easier to challenge. Does that? I'm
Yes.
trying to think of the policy reasons for having the two different tracks.
Yes, as you've explained it, that's correct, Your Honor.
I'm sorry, did you have a follow-up, Judge? No. So the 812, the purpose behind writing 812 the way they did was to say, we're going to set up something that is recognized as effectively a non-appealable after the review period or the appeal period is run, which we're defining. Then after that, that's the law. It's not a presumption anymore. That is the law as regards that issue.
Yes, Your Honor, that's correct.
Was there something that prompted the need for that? I mean, were there people that were abusing the presumption somehow, and so they said, we're going to make this this appeal issue a done deal? Or was this just somebody's thought about how we're going to extend this law?
I believe part of the policy reason for that was just the need for the child to have permanency, and this was a way to prevent an attack on a presumption.
What is your response to the argument that Mr. Abney raises about the particular form of duress that's been alleged here doesn't fall within the 6-month time limit of 85C, because it's not duress by the adverse party, it's duress by someone else?
Well, the legislature mandated that there be only 3 grounds on which a voluntary acknowledgement of paternity could be attacked. And it doesn't define what type of duress, but certainly it doesn't limit it to just duress from an adverse party. So just reading from the plain language of the statute, it would seem to me that it would be included within that.
I think the argument, though, is it doesn't turn on the meaning of the statute, but the meaning of the rule. I think the argument is under 85C, the duress, which is for which you may obtain relief only within 6 months after entry of the judgment, is labeled duress by an adverse party. I think that's the argument, as opposed to any other sort of duress.
He's not entitled to relief under any provision of 85C, because first of all, he never alleged in either, the father never alleged at the hearing or in his Rule 85C motion that he was filing the motion under anything but Rule 85C3. Although in his motion, he did state also material mistake of fact. That's really not a viable argument, in that he also alleges that he had stopped his sexual relationship with the mother a full year before the child was born.
But I want to make sure I understand what you just said, because I think it's important and may be responsive to Mr. Abney's argument. So in the Superior Court, his claim was that he was proceeding under 85C3 and a material mistake of fact. And so then we're right back into the language of 25812E.
Yes, Your Honor. And so by failing to allege any of the other grounds, 4, 5, or 6, subsections 4, 5, or 6, then those arguments have been waived. Second, well, as we've discussed, that the statute itself limits the grounds on which it could be challenged to only 3. And the next point is that because father let his time clock run out on his statutory remedies, that does not entitle him to any equitable relief. And duress, as he's made the argument now, may be something that could trigger equitable relief, but he's not eligible for that relief, because our Supreme Court has specifically stated that, quote, where the legislature has spoken by statute, we will not construe Rule 60C so as to interfere with the proper application of those statutes. And that's in re Marriage of Waldron at 217 Arizona 173 on page 177, paragraph 22. And this court has held that when the, quote, legislature has clearly spoken by statute on a substantive matter within its domain, the courts will not interfere under the guise of equitable powers with proper application of such statute, end quote. That's Hobson v. Mid-Century Insurance Company, 199 Arizona 525, page 532 at paragraph 20. And as far as the last subsection of Rule 85C, that's the catch-all for any other reason justifying relief from a judgment's operation. That's not available because Andrew R. expressly stated that a Civil Rule 60C motion to set aside cannot be brought on subsection 6, the catch-all ground, if it is premised on any of the other 5 grounds. And father also can't circumvent the timeliness requirements for Andrew R. set by seeking to terminate his rights under ARS Section 25-503F. The first sentence of Section 25-503F clearly and unambiguously states that it applies only when a person has been ordered to pay child support based on a presumption of paternity established under ARS Section 25-814. So it is legally impermissible for him to seek that relief. As this court has discussed, Section 25-814A4 has a mere presumption of paternity, while Section 25-812D, the determination of paternity under that statute is determination of paternity having the same force and effect as a Superior Court judgment. Father does not make any serious argument on the applicability of Section 25-503F. His cross-reference argument is nonsensical. Father also raised a due process claim for the first time in his opening brief. By failing to raise it in the trial court, it was waived, even assuming that fundamental error review is available for an unpreserved error. in a child support matter, his claim fails because he failed to establish both fundamental error and resulting prejudice. The United States Supreme Court has held that, quote, a statute creating a presumption which operates to deny a fair opportunity to rebut it violates the due process clause of the 14th Amendment, end quote. That's Vlandis v. Klein, which is cited in both the opening brief and answering brief. Here, father did not establish fundamental error because he failed to demonstrate that Section 25812's procedural safeguards were inadequate to afford him an opportunity to challenge the acknowledgement. First, the notice of acknowledgement itself put father on notice that he was relinquishing his right to a court hearing to determine paternity, as well as his right to have genetic testing done to determine the parentage of the child. He also acknowledged that he might have a right to challenge his acknowledgement as outlined in ARS Section 25812. The next safeguard is a 60-day rescission period during which a parent can unilaterally rescind the acknowledgement. And because the child had turned 2 months old just 5 days after father executed the acknowledgement, and he testified that the child could have been as young as 2 months old when he allegedly had the genetic testing done, then he could have unilaterally rescinded the voluntary acknowledgement at that time. Moreover, if his claim is true that he stopped his sexual relationship with the mother a full year before she had the child, then he must have known that he could not have been the father, and he could have filed a Rule 85C motion anytime within the 6 months from signing the acknowledgement of the paternity.
May I interrupt you and ask you to go back to 85C again? I'm sorry. 85C 1C, 85C 1A allows a party to seek relief from a judgment on grounds of mistake, inadvertence, surprise, or neglect. B, C1B, newly discovered evidence. C1C, fraud, misrepresentation, or other misconduct of an adverse party. Why do we think that encompasses the argument here, which is that the misconduct was not by the mother, the adverse party, but by some other party?
Well, the so-called misconduct has not even been established. It's been alleged, but father's own testimony is inconsistent. It's fraud, however it's defined by if it's by an adverse party
Or other misconduct of an adverse party. Fraud, misrepresentation, or other misconduct of an adverse party.
Well, mother was not an adverse party at the time any alleged misconduct in the form of duress took place.
But the argument is, this is not his argument. His allegation, the motion for relief from judgment, he's arguing, was not pursuant to C1C, fraud, misrepresentation, or other misconduct of an adverse party, because it was grounded instead on another reason, any other reason justifying relief from the operation of the judgment, because it alleged misconduct by the mom and or by his parents.
Well, Andrew R. itself expressly stated that the catch-all provision cannot be used if it could have been alleged in any one of the other grounds.
But the argument is it doesn't fall within any of the other grounds. What other ground do you think this argument would fall in?
It could have fallen under subsection 5, and that would be any other reason justifying relief from the operation of the judgment.
Well, that's the.
I'm sorry.
Yeah.
Let me see. If I may refer to the 85C. So it would fall under it is no longer equitable that the judgment should have prospective application.
E,
So, E, yes, Your Honor.
or is no longer equitable. Well,
And that ground was not alleged. And so it has been waived. The other reason why fraud from other than an adverse party should be excluded is if this provision is used, it will just circumvent Andrew R.'s timeliness requirements, and then the floodgates will open. The legislature narrowed the grounds to 3, and the Supreme Court in its in this court, in deciding Andrew R., applied the time limits, the 6-month time limits to those 3 grounds in order to limit the collateral attacks on paternity.
well, it applied the rule. It said the rule applies to a motion for relief. Right. Whatever the rule says.
Yes, as far as the time limits.
Okay,
If the court has no further questions, the state will rest.
thank you.
Duress was a big part of the presentation to the court below. Mr. Ayi spoke about it at the proceedings on June 3rd, 2014. But he also presented affidavits from his mother and his father talking about the duress. I cite those in pages 4 and 5 of the opening brief.
But what legal grounds did he specify? According to Ms. Salvati, he only alleged 85C3 and material mistake of fact. Is that accurate?
I do not think, no, that is not accurate. The argument presented to the court below was duress and fraud and material mistake. The fraud by the
motion for
mother
new trial,
was fraud, duress, and material mistake. And the fraud by the mother, his theory was that the mother knew the truth and was still trying to get him established as the father.
yeah, I'm just trying to determine whether any particular rule sub-paragraphs were cited as the basis for relief.
I do not think that there was a good differentiation made at the trial court.
But in this proceeding, the mom's not the adverse party either.
Correct. But the theory was, at least for his fraud, the theory was not that his parents had anything to do with that, other than accepting at face value what she had told him and then what she had told to them.
But an argument, I mean, the adverse party here is the state. There was no contention that there was fraud on the part of the state, fraud or any sort of misconduct.
Right.
On the part of the state. The argument was misconduct by mom and or parents.
And the statute doesn't differentiate where the fraud is coming from.
Well, the rule does.
The rule does, but the
rule
statute doesn't. And if you're going to incorporate the rule into the statute, which was what Andrew R. Did, then I think you have to take the baggage of the rule with it. And the baggage of the rule here is you've got a very limited number of things that you can use. There's certain ones that are that fall within this 6-month black hole, and once you're past the 6-month period, you're dead. But there's others that survive, and I think we would fit the catch-all.
Would probably lose on it being filed within a reasonable time.
Oh, yeah, unless duress is there, we're just dead in the water.
But, well,
It's kind of a hollow or Pyrrhic victory, isn't it, to say you got through the door on duress under F, but you're out the door because it wasn't filed within a reasonable time.
Well, no, what I meant to say was that if duress isn't there to save us, then on fraud and the other thing, we're dead. Duress is the only thing that's really going to rescue this. If you say that 85C is incorporated in the statute, and I think we're stuck with that. But then again, if you say that, then I do get a small chance for a full victory. I know it's small, but it's the duress escape hatch.
and what Judge Downey, I think, is saying is that under 85C2, even if you can exceed the 6-month limit, it still needs to be filed within a reasonable time. So
Sure.
that would raise, that'd be a question that would have to be resolved by the trial.
Yeah,
judge.
and when you think about it, he's sitting there, I hate to say fat and happy, but he's sitting there just sort of dumb and unknowing and thinking this is all gone away. And she knows that this is not my child and she's not going to make any demands on me. And then out of the blue, she doesn't come in the door. ADES arrives and says, hello.
So your argument would be in the trial court, he didn't have any reason to do anything else because the mom, knowing the truth, he would say,
Correct.
walked away.
Correct.
Why would he think this has all gone away?
You-
It's been filed, it's been all the things under statute that are required. And I realize he didn't sit down and read the statute to understand that.
Sure.
What is it in his mind that says, I signed it, I agreed to it, I admitted to it, I haven't objected to it, I had DNA tests that I haven't even bothered to provide to anybody to dispute it, but it's all gone away?
But he had the DNA test that he told the mom about, and then immediately that's the end of any relationship. The child is removed from the 5-day-a-week tradition with the grandparents and the dad, and never comes back.
Yeah, but that sounds like a lot of visitation arguments I've heard. I was denied access to the child. Why should I have believed that I still had to support the child?
No, it's not denial of access, just that the child goes away
Well,
because
the mom goes away. The mom says,
goes away.
okay,
Yeah.
yeah, that's right.
And he's not seeking visitation because he thinks, I showed her the paternity results, I saw the paternity results, and it's not my child. And so she saw the light too, he thinks, and she's gone away. You, I hope, and the other members of the court and every lawyer in this courtroom would want to nail this down and get some sort of judgment or decree that unravels everything and you're in the clear. But he's not that sort. And, that's a problem. But then again, it's one of those problems that a lower court should deal with directly. And as one of the factors in what to do and what not to do. But I could... Reasonably speaking, a layperson might say, in his position, could say, well, she saw the light. I don't need to worry about anything else. I can get on with my life.
Thank you, Counsel.
Oh, thank you very much. Appreciate it.
Thanks to both of you for your arguments and for your briefs. We'll take the matter under advisement and issue a ruling in due course, and we'll stand adjourned.